the first case. It is from Sedgwick County. It's number 128764, the state of Kansas versus Antonio E. Smith.
May it please the court, Antonio Smith appears through counsel Casper Shire, Kansas appellate defender. Antonio is also with us in the courtroom here today. Could I please have 3 minutes for rebuttal, Your Honor?
That is granted. And who do we have for the state?
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Mr. Shire, whenever you're ready.
Thank you, Your Honor. The threshold question in this case is whether an undercover officer offering sex for sale on North Broadway, part of a sting operation, can still become a person who sells sexual relations. If the answer to that question is no, then the case against Antonio has been a non-starter from the beginning. We maintain the plain language sufficiency argument that Antonio made in the district court. A person cannot become something that they already are. Even viewed in the light most favorable to the state, the evidence here does not support the crime the state charged.
What if you're just pretending to be somebody? Can you still then become a prostitute if you're just pretending in the first place?
The facts of this case are that the intent of this officer was to present herself as somebody out there selling sex. Antonio was ultimately convicted of the attempt to promote the sale of sexual relations. So part of the crime here is that Antonio had to have the specific intent to pull somebody who was not in the business, so to speak, into the business. And when someone is out there presenting themselves as somebody who sells sex, who's complaining about having to crank it out for $30 a pop, that's somebody who's presenting themselves as in the business. And the state has not proven that she could become somebody in the business for the purposes of this prosecution.
So how are you defining become?
I define it as a change of state. And we provided dictionary definitions. I think both sides provided dictionary definitions in their briefing. And the key language here is not just become, but the statute actually specifies what it is that you have to become: a person who sells sexual relations. So it can't just be become somebody who continues to sell sexual relations under different circumstances. That is not the statutory language. The statutory language is become somebody who sells sexual relations. And if you're already out there doing that, you cannot become that.
Do the PIC instructions mirror that as well?
The definition of become?
No, to become a person who sells sexual relations.
I believe so, Your Honor. I have to double check, but I think that's how the jury was instructed, yes.
Does that fly in the face of the public policy arguments for why this statute might have been passed?
I don't know. I haven't given it a lot of thought, because the first place we have to look, Your Honor, is the plain language. And the plain language says what it says, which is you have to become a person who sells sexual relations. And frankly, you know, I can think of a reason why the legislature would want to criminalize pulling somebody that's not into the life, as opposed to approaching somebody who's already selling sexual relations and trying to convince them to change their business model. Those are two different things, and I can see a reasonable legislature thinking that the first is worse than the second, and choosing to criminalize the first and not the second.
There's nothing new about this statute, right? It's been around a while.
Yeah, I don't know precisely how long it's been around, but no, I don't think this is a new provision, Your Honor.
Yet there's very little Kansas case law interpreting this particular situation, correct?
That is true, and the district court, and I think the parties as well, all acknowledge that. I wasn't able to find any, I think based on my my opponent's briefing, he wasn't able to find any either. So I think we are here in this court to tell us what it means to become somebody who sells sexual relations. Does that require a change in state?
Have we looked at what other states have said on that similar issue?
I have not, Your Honor. I would just go back to our Supreme Court, our Kansas Supreme Court's expressed preference for looking at and applying plain statutory language. And that means become a change of state, a person who sells sexual relations. You have to go from somebody who's not to somebody who is.
But that defense was able to be presented at trial or not able to be presented?
It was restricted, Your Honor, and that's the second problem with this case, as we've raised it in issue 2. The district court did consider a motion to dismiss on this issue, ruled against Antonio. That was renewed with a directed verdict motion at the close of the state's case, as is very common in virtually every trial. And then when Antonio's attorney tried to present this defense to the jury, he got cut off by state objection. And he was effectively told that the court read a special instruction, which I found confusing. And Antonio's attorney had to move on to the second defense, which is that, you know, none of this was serious anyway, right? He didn't get a full and fair opportunity to litigate this particular issue to the jury. The district court expressed a belief that, hey, this is a legal question. I've ruled on the legal question. That settled, the jurors are just there to find the facts. And that is, in our view, a fundamental misunderstanding of the jury's role in this situation. Jurors are where the rubber meets the road. They are the ones who apply the facts as they find them to the law. Just because you've made a sufficiency argument and it's not successful does not mean that you cannot present exactly the same defense to the jury. In fact, that is routinely what defense attorneys do. As a class of people, I don't think I'm revealing any, deeply held secrets of the defense bar in saying we generally attack the state's case where we believe it's weakest. So the same place we're making a sufficiency argument is the same place we're going to take the case to the jury. And when you restrict an attorney's ability to do that, you are denying the ability to present a complete defense and denying Antonio a fair trial.
If we agree with you on the first issue of insufficient evidence, does that moot all the rest of your arguments?
Yes. The final thing that I'll try to hit before I close at least the opening portion of my remarks is the prosecutorial error argument, the argument that asked jurors to infer that because Antonio was volunteering his time as a youth basketball coach, that he was using that 5th grade girls basketball team as a feeder program for a sex enterprise. That was wholly unsupported by the evidence. It denied Antonio a fair trial. Nobody is going to get a fair trial where the state is throwing around ungrounded accusations of child sex trafficking.
But there was an objection at trial when he stated, was there?
There was no objection, but it was closing argument, so it is reserved for this court's review.
Sure, I understand it's preserved, but does that show you the weight of the prejudice if there's no objection by the defense counsel?
I think the current case law on that is, that's a factor perhaps this court can look at. But the toxic nature of this kind of accusation. This is essentially 6455 evidence of the worst kind, coming in by a closing argument. And all of the issues, all of the baggage attached to 6455 evidence come along with this. You know, it's propensity for one, because I mean, jurors believe that attorneys know more about these cases than they do. And they believe that correctly. We do know more about these cases than we do. So when you have a prosecutor coming in, you know, maybe you haven't heard, he accused Antonio of doing this in his cross-examination. That is not evidence, and Antonio denied it. Then he gets up again and says, you should infer that that's what's happening. That is propensity evidence against Antonio. That is very damaging to his credibility in a case where credibility was very important, where Antonio testified about what the nature of his conversation with this undercover officer was and how he meant it as a joke. And it's also brings up this factor that this jury is going to punish Antonio for something that the state is suggesting that he's done to children rather than because they've met their burden of proof in this case. So for all of those reasons, it cannot be harmless.
Does it suggest evidence that's not by that state? His enterprise being prostitution involving the basketball.
There was nothing involving the basketball team in the record besides Antonio offering for the jury as part of his testimony. When you're accused of being a pimp, you need to tell the jury how you actually spend your time, and he did. There's no evidence that he was using his status as a youth basketball coach to do anything inappropriate.
Right.
You've used 12 minutes.
And I think I've touched the things that I hope to touch on, so unless there are further questions at this point, I'll save my remaining thoughts for rebuttal. Thank you, Rob.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. I will confine my remarks this morning to the first three issues as well, unless this court directs me otherwise. Regarding the first issue, what I've heard argued today is that this court should rely on the plain language. What I do not hear the defendant saying that there is any ambiguity in that plain language. In fact, the parties all agree on the definition that should be applied here. The defendant simply wants to ignore half of it. The definition that both parties cited in their briefs came from Merriam-Webster's dictionary, and that become means to come into existence, to come to be, or to undergo change or development. So while the defendant's argument is one form of how someone could become someone that's selling sexual relations, the state asserts and maintains that he is ignoring the undergoing a change or development, because that is exactly what the defendant in this case did. He attempted to recruit an undercover officer to come and work for him as a pimp. She wasn't getting enough money, in his opinion. He couldn't get her to make more, that she would then sell herself and he would profit from that.
Is that in the statute though? If the statute reads inducing another who's 18 years of age or older to become a person who sells sexual relations, not to become a person who's going to make a lot more money selling sexual relations. Are you putting words into that statute?
No, Your Honor, the state is not putting words into that statute because you have to understand the meaning of become. To become someone that sells sexual relations, it can mean, as the defendant claims, to do it, to initiate, to induce someone to initiate their selling of sexual relations. But that ignores the additional meaning of become that we all agreed on, and that is that become also includes to undergo a change or development. An analogy that I feel is apt, in addition to the NBA analogy that was argued here.
Sure, so help me out, what is the change of development that was presented for the jury's consideration?
It's, as I explained, the officer was complained to the defendant about the rates she was able to receive here in Wichita. Hypothetically, she was pretending, obviously. And the defendant said that she told her that she could get a lot more money working for him, that he worked girls in in the Kansas City area, he managed them, that he would offer her protection, things of that sort. Basically, instead of working.
Refresh my memory, was the jury given an instruction on what he just defined as to become?
No.
So how would they have known to resolve this case?
Because the plain language, the state maintains that the plain language is clear. To make people understand what become means. Another easy hypothetical that I could make here today, Your Honors, is if opposing counsel and I decided to change offices, if I were to apply to his office, he were to apply to mine, we would switch places. I would become an assistant appellate defender, he would become an assistant district attorney. Everyone can understand that. It is genuinely that simple. The argument that was made today that the legislature would prefer to criminalize just inducing an initiation of selling sexual relations as opposed to forcing or inducing someone to change their circumstances and become beholden to someone else, candidly makes absolutely no sense. And if there were any ambiguity here, the defendant at no point has pressed back against the state's policy arguments that it set forth in its brief regarding the canons of instruction and in par materia analysis. This is a broad sweeping statute to protect individuals from becoming either people that sell sex or people that sell sex under different circumstances, including that where they may be beholden to a pimp.
Okay, so help me out. I'm still struggling with your argument.
Okay.
Okay. Promoting the sale of sexual relations is knowingly. Or, and so how am I reading that plain language? So you're saying to become means to undergo change.
Correct.
So let's insert those words in the statute, okay? Plain language. Inducing another who's 18 years of age or older to undergo change. Undergo change as a person who sells sexual relations, okay? So I've just put your new definition in the statute. How does that change the argument?
I don't think you've added anything to the statute. You've applied the plain meaning of become.
Right, and how does that fit this situation? To undergo change.
Mhm.
Are you saying change means? How are you defining change then? Because I'm still not following your argument.
I think change is clear. It's contained within become. I mean, what we're talking about is someone, and it's argued in my brief. Yes, one type of becoming someone that sells sexual relations can be someone that is induced to initiate that sale. And that's what the defendant is arguing for here. But that's not what become someone that sells sexual relations means. That's not its exclusive meaning. It can also mean to become someone that's selling sexual relations under different circumstances. And that doesn't require reading anything into the statute. It just requires applying the plain meaning of the word become. Does that help?
No,
No.
I'm struggling with it. I'm struggling with it because I think you're adding words in the statute.
Okay. And I guess my pushback to that would be is the state is certainly not trying to do that. That's not proper statutory interpretation. We're trying to apply the plain meaning. And if what your honor is suggesting is that there may be some ambiguity with the meaning of the word become, that ambiguity is resolved by the remaining arguments in the state's brief by applying the canons of construction.
Well, I'm a little confused here. We have to find some ambiguity to even get to the canons of construction or
Correct.
legislative history, right?
Correct.
And
And
you're saying there's nothing ambiguous about this,
that's correct.
even though I think this is one of these cases where both sides say it's unambiguous, but they can't agree on what it means.
I think both sides agree on what it means. I think one side is trying to create ambiguity where there is none. The state is simply trying to apply the plain definition of become straight from Merriam-Webster's dictionary, the same definition that a common reasonable juror would have understood applied under these circumstances. My only suggestion is that in the circumstance where there should, if this court were to agree that there were any ambiguity, then you move to the canons of construction. And in that instance, the state's position is candidly much stronger, even much stronger still, because of the impar materia analysis. In fact, this is part of chapter 64. This is a crime against public morals. It's not a sex crime. It's not a person crime. And then as well as the arguments that I presented in my brief about the surplusage canon and another one that I dare not try to pronounce today in Latin.
I struggle with it as well.
Yeah.
It's always, okay. Could it be so simple as this, and you're gonna hate the question, could it be so simple as this? We're gonna follow the plain language of the statute. And here, the person who solicited him was already a prostitute, and therefore he could not induce her to become a prostitute since she already was. So could there be absolutely nothing wrong with the statute whatsoever? That's why it's been on our books for quite some time. Until you come to a case like here, where he's being prosecuted in a way that doesn't match the facts. Is that a possibility?
My answer to that is that it is a possibility, but to bring that possibility to bear would be to abandon this court's duty to apply plain meaning
Sure.
and the alternative to turn to the canons of instruction. It would be for this court to insert its judgment, your three individuals' judgment about what you think become means, as opposed to its common meaning. And what it's clearly intended to mean as it's set forth in the statutes.
Did you attempt to do any legislative history on this? I don't recall that in the brief.
No, Your Honor, candidly, what we argued was the impar materia analysis, focusing on the fact that it is in the chapter 64 crimes against public morals. It makes sense to be there when this isn't. When we're talking about changing someone's circumstances, we're further undermining their morals. That makes sense for this statute to be there. Subjecting them to a change in conditions, a development in their already perhaps distasteful life choices. It makes sense that the legislature would want this there. And for what it's worth, I did note that there were questions about this officer was indeed pretending. And I think both parties perhaps could have pushed that a little bit further in our briefing, but this wasn't someone that was actually selling sexual relations. She was pretending to be. So I think that there may be an argument, there may be something there about become, but again, we would maintain our focus on the arguments that were made in our brief. Briefly, if I may, on issue 2 about the state maintains that the constitutional argument was not preserved here. And that what happened here is that the district court made a finding as a matter of law that is not the province of a jury. The defendant was still allowed to present an argument that as a matter of fact, he did not attempt to induce this officer to become someone selling sexual relations. But he was what the parties could not do was try to redefine the law for the jury. That's all that happened.
Did you want to touch on the misconduct?
Sure.
Here?
I'm going to focus on just the first claim unless this court has questions about the second. But the argument about the defendant, it was a rhetorical question that the prosecutor posed to the jury whether the defendant used a youth basketball program as a feeder program for an alleged prostitution enterprise. The state maintains that to a certain degree, arguments aren't always necessary, but this one, while maybe not necessary, was rooted in the evidence here. We had the text messages from the defendant's phone that were photographed that admitted in evidence. One of them was the defendant texting an individual telling her to bring her daughter with you and we can take you to turn some tricks or dance and get it now. There were at least 3 instances where the defendant was referring to an enterprise that were in direct relation to his pimp enterprise, having individuals sell sex and split the money with him.
But none of those related to 5th grade girls on the basketball team, correct?
None of them directly did.
Wasn't it wild speculation for this attorney to make that argument in closing argument?
I don't know that it was wild speculation. I think it was pointing out all of these individual facts that were proven. And I think, I guess one thing I would point out is the defendant was specifically asked if basketball travel tournaments wasn't part of your enterprise. He answered no. That could be an unintelligible double negative, or it could be understood as a refusal to deny a relationship between his roles in the sex trade and his coaching program, where he was traveling all over the state of Kansas. That's a reasonable inference that could be drawn from that question alone. The evidence was in the record that he did travel all over the state with these basketball teams, including trying to get exposure for individuals for college programs. He was later asked, is it your testimony today that the enterprise you referred to isn't the 5th grade girls basketball team and your pimp business? It is what again? And the defendant did not expressly deny that the girls basketball team was part of his enterprise. Instead, he claimed that this enterprise was all just a joke. It wasn't just a joke. And I think that's what the prosecutor was trying to drive home. This isn't a joke. The prosecutor did not assert that the defendant was using the girls basketball team as a feeder program. He asked the rhetorical to help illustrate that the defendant's intent here was clear.
So it was rhetorical,
It was rhetorical.
those statements at closing?
Yes. This
Should a
complaint does.
prosecutor make rhetorical statements with respect to a 5th grade basketball team? Isn't that, I understand we allow rhetorical questions, but isn't that a bit inflammatory?
It could be in different circumstances. I would say it's not here. Based on the evidence that was. I think I'm probably up against my time.
You just used your time.
If this court doesn't have any further questions, the state would submit the remaining issues on our brief and ask the defendant's conviction be upheld. Thank you.
Counsel, let me just lead off with some questions.
Sure.
If your interpretation of the statute is correct, it would be impossible to prosecute anyone under the statute who was arrested in a sting operation. Isn't that right?
It would take a different kind of sting operation. The officer would have to be presenting as somebody who's desperate and looking for money, but not currently in the business. Something like
Most
that.
of the prosecutions under this statute are result from a sting operation like we had here.
That's right, Your Honor. No, that's absolutely right.
And then my final question, if the statute read inducing another person who is 18 years of age or older to engage in the sale of sexual relations, that would fix the problem, wouldn't it?
Well, to the extent that you see this,
I'm getting to get rid of the words to become, if it said to engage in the sale.
it would undercut our sufficiency argument. Yes, it would, Your Honor. And I think sort of sting operations do come with baggage. That's the reality of sting operations. And I think the result here is the state was left trying to pound a square peg into a round hole, and it just doesn't fit. Just doesn't fit. And I think Hillard is instructive on that point. Hillard is a case where our Supreme Court vacated a conviction for distributing drugs when the theory was that she intended to distribute them to herself. You can't do that. You can't distribute something to yourself. And in the same way, you can't become something that you already are. And we do believe that this court should reverse the conviction on that basis. And for all of the other reasons that we put forth in our brief.
All right, counsel, thank you very much
Thank you, Your
for
Honor.
your briefs and your arguments.